Good morning. Hi, I'm Ruth, and as you've just heard, I'm from the Centre for Environmental Rights. You probably won't all know, though, that what the Centre for Environmental Rights is. It's an environmental law clinic and basically an NGO based in Cape Town. Now, before I start, I'd just like to allay some fears that I know have cropped up in the course of the conference. I am not a member of the EFF. This is despite my beret. You've got to be very careful about the politics of beret color in this country. Well, that's what my next talk will be on. Anyway, so jokes aside, I'd like to speak to you today about the zero-sum game that is conservation. You won't yet know quite what I mean by that, but I hope by the end of the talk you will. So just to give you an overview, I'm going to speak first about the conflict that is caused or that is created by conservation goals as they stand in conflict or in contrast to private property rights. I'm going to be putting that into the context of South African history and politics, and then speaking a little bit about how that conflict has been resolved and the challenges that we've faced. Right, so first of all, we need to set out the rules of the zero-sum game. As we've heard several times in this conference, South Africa is a signatory to the Convention on Biological Diversity, and the CBD sets out various targets for protected areas and the protection of biodiversity in general, as we all know. The target that is set for terrestrial land that should be protected the world over is 17%, but our South African target is a bit lower than that. We're only trying to get 12% of our terrestrial land under protection, which sounds like not very much, but it's definitely more than what we currently have under protection, which is 6.5%. I'm just going to bring this down a little bit. Yeah, cool. Right, so that sounds fairly straightforward. We need to increase protected areas, but it's not all that straightforward because of private property rights. 79% of South Africa's land is what I mean, is currently owned by private people. And so that makes it a bit difficult if you want to expand protected areas, particularly in relation to the private property protections that are provided by Section 25 of our Constitution. So we are left with a conflict and a zero-sum game. We have a certain amount of land in the country, and a whole lot of that is privately owned. We can't really move around very much within that dynamic, or we haven't been able to in the past. And so there are various strategies that have been adopted to kind of resolve this problem. And in the past it was very easy. But people, whilst the South African government was very fond of evicting people from land, they didn't care about the trauma involved, they didn't care about the needs or the rights of people that were not white, and it was very easy to declare protected areas. This means, of course, that in the land reform policies that are now evolving, the protected areas are quite important. Many land claims are actually on protected areas, and so we need to acknowledge the linkages between land reform and the expansion of protected areas. So now today, of course, the strategy for protected area expansion is quite different and a lot more complicated. We have various tools that we use for this, or ingredients. If we're going to think of it like a protected area pie or something, we have various ingredients that we would use, and these are legislative tools. The first of these is the Protected Areas Act, which was passed in 2003, and basically allows for the minister or the MEC in a particular province to declare protected areas and provides the protections for those areas. Following that, there was a spatial diversity, a national spatial biodiversity assessment in 2004, which that was done so that we could find out how much biodiversity we actually have, where it is, how much is protected, and the conclusions that they reached was that only 6% at that point of our land is in fact protected. By 2011, that had gone up to 6.5, but that's still quite far away from our target, which was established in the National Protected Area Expansion Strategy in 2008. And this strategy is what leads us to a certain recipe for protected area expansion. First of all, in this recipe, we need to decide on the location of our next protected area. And that depends on various factors, well, two big factors really, importance and urgency. The importance of the piece of land in terms of the ecological processes, the ecosystem services that it provides, its biodiversity, it's biodiversity. So that's the importance, but then also the urgency plays a role. And that speaks to the amount of land that we still have, representing a certain ecology or a certain biodiversity, and also the various pressures that there are on that land. There may be pressures in terms of mining rights. There may be pressures in terms of all kinds of development, really. And so that if a piece of land is more urgent to declare, then we'll be more likely to declare it as a protected area. But then the next step is to decide what form of protected area we would like to establish. The Protected Areas Act makes allowance for various different kinds of protected area, depending on the importance of that area and the protection that can be given to that area. You can declare wilderness areas, you can declare nature reserves, national parks, special nature reserves, and also protected environments, which have the least protection of all of those. Now, the next step in this little recipe is to decide what kind of mechanism you're going to use to declare the protected area. The simplest mechanism is just to acquire the land and then declare it. But that's not really all that easy because land is expensive in South Africa, and it would be state funds that we'd have to use to do that. Somebody worked out, I think, that if we were to buy up all the land that we need to meet our protected area targets, we would need something like 23 billion rand, which we don't really have. So for that reason, we kind of need to adopt other mechanisms. The contract mechanism is one that's been kind of preferred. That involves a negotiation with landowners. The piece of land would then remain in private hands, but the landowner would agree to certain restrictions on the use of that land in return for support in the maintenance of the protected area. I'll be speaking a little bit more about that. But then the final mechanism that can be adopted is the simplest one. If the land is actually owned by the state, then obviously the state can just declare it. So once we've decided on a mechanism, the minister or the MEC in a particular province can make the declaration that a particular area will be protected. And then there's obviously a bit of a consultation, public participation process that you need to enter into. And then, hey presto, you've got a protected area pie. Right, but it's not actually as easy as all that, I'm afraid. There are various challenges that have been seen, even though this process is so new. There are already various challenges that have presented themselves. These are firstly in respect of additional rights that can be held to the land, specifically mining rights or prospecting rights. The Mineral and Petroleum Resources Development Act, mouthful, that act effectively separates the rights to surface rights to a piece of land from mineral rights. Mineral rights vest in the state, but surface rights can obviously be privately owned, and so that creates a bit of an interesting distinction, so that the landowners are consulted and need to give their consent if their piece of land is going to enter into a protected area or a protected environment or something like that. But the mining companies that might hold rights to mine or prospect on that land won't necessarily be consulted, and those people have been those companies have been objecting. And to explain that a little bit further, I'd like to discuss some examples in Mpumalanga. Mpumalanga is the perfect place to discuss this dynamic because of the extent and importance of biodiversity in that area. I mean, it's where the Kruger Park is. There are very important ecosystems that we need to protect there. But at the same time, Mpumalanga is also where most of our coal comes from. And there's a whole lot of other mining there too. I mean, we get gold there, all kinds of things. But coal is definitely the biggest one. In 2009, 220 of the 250 million tons of coal that we produced in South Africa came from Mpumalanga. So that's the hub. But Mpumalanga hasn't been doing too badly. Just this year, there have been several protected environments, not protected not national parks or nature reserves, but protected environments. There have been several of those declared. Protected environments are a slightly different animal from what you would think of when you hear protected area. When I think of protected area, I think of national parks, that are quite, well protected. Protected environments, though, are a bit different. The emphasis there is on sustainable and compatible use. In fact, you can even mine on a protected environment given the permission of the minister or the MEC. But yeah, in any case, so these are all protected environments except for the Tafelkop Nature Reserve, which is a bit different, and that's privately owned. No, actually, they're all privately owned, it's a bit different. Anyway, so just this year, there have been several protected environments declared, and 2 further protected environments have had a notice of intention to declare published. So they're not doing too badly. But what's interesting to note here is that there have been various objections, as I've already mentioned, from mining companies. And I think it's quite important to engage with these objections if we want to be pursuing the protected area expansion mandate and actually increasing our protected area. Or at least, following biodiversity goals. So the first of these objections that is kind of most fundamental actually is the deprivation of property objection. Basically, mining companies are saying we have property, we have a mining right or a prospecting right, which is private property, and that we are being deprived of that. Now, the guidelines that are provided by the FNB versus the Commission of SARS case are, you can see them on the slide, you don't need to read them in detail, but basically you need to think about whether you're talking about property, which you are, whether you're talking about deprivation, which you are, but then whether that is consistent with Section 25.1 of the Constitution, which sets out that you cannot be deprived of property unless it is by a law of general application, and that is not arbitrary. And in this case, I would argue that it is consistent because, well, I mean, I've spoken about the legal tools that can be used to enable protected area expansion, and these are all laws of general application. They don't target a specific person sitting on a specific farm. And in addition, it's not an arbitrary process. There's a lot of thinking that goes into it. I was speaking about the way in which you identify the location of a protected area and the processes that you go through to do that. So it's not arbitrary. That's how I would interpret it, or others would probably do that differently. But if you do that, then you need to justify it in terms of Section 36 of the Constitution, which is the limitations clause. That's the clause that speaks about when one right limits another right. So when the right to a safe and healthy environment under Section 24 limits the right to property under Section 25, for example, that's quite complicated and involves a balancing of rights. And I would argue that we could still come out on top there because of the importance of biodiversity and the importance of a safe and healthy environment for ourselves, but also for generations in the future. And I think that the way to just keep answering that objection is to keep researching the dynamic and keep using that research and making sure that people know about that research. Okay, so that's the first objection, and that's what I'm going to speak most about. The second objection that has been seen in almost all cases, actually, is that of procedural fairness. That's kind of going into the itty-bitty of the process and trying to pick out what may or may not have gone wrong. Mining companies have said that there wasn't enough consultation, that they didn't get enough information about what was happening, and several of them have said that they must be able to make oral representations to the MEC, that it is their right. But I would caution them slightly because, in fact, there is no prescribed consultation time frame as long as the time frame that is given is reasonable. And the time frame that has thus far, in the cases that I mentioned, the time frame that has been given has been about 60 days, which I would that's for consultation or submissions. And I would say that is reasonable. Obviously, people can interpret that differently. And then also there is the issue of locus standi, or the right to engage, to the standing in terms of the court or the legal process. So basically the the mining companies are saying that they have the right to be consulted by the MEC or the minister, so that that person might obtain consent from them, and that they must be able to do oral representations. That is not the case, though. Only landowners need to give consent, and the MEC may, not must, but may allow oral representations at his or her discretion. So yeah, that's something I think that also needs to be remembered. And then the third and final common objection I just want to mention is interference with economic development. Mula. Yeah. So basically the mining companies are saying that they could be providing all this employment and they're not going to be able to do that because they can't operate. This will lead to economic growth, and then they also have argued that the declaration of the protected area is leading to their own personal economic loss, which is not really relevant at all, but yeah, that's what they've said. And what one can say in response to that is that there is an emphasis on economic growth through tourism specifically in pretty much all the protected area expansion legislation, in the strategy itself, in NEMPA, the Protected Areas Act, in all the specific Mpumalanga policies. I mean, I'm talking about Mpumalanga specifically now, there are others as well, but the national acts mandate provinces to create their own legislation. One moment, and that's what's been done. In addition, as I mentioned before, mining is actually permitted on protected environments with the permission of the MEC or the minister. So I think that's why it could be counted. Right, so that's what's happening currently, and at this point I just want to be a spoil sport in our little zero-sum game. I'd like to just throw a couple of spanners in the works, things that I've been thinking about. First of all, I mentioned before that land reform needs to be intricately linked to the expansion of protected areas in South Africa if it's going to be effective. And the National Protected Area Expansion Strategy, does actually emphasize that. It states that land reform is not at odds with the expansion strategy, and actually encourages a process whereby the claimants would then enter into a contract agreement with the state, and that would lead to co-management agreements or stewardship. However, there is quite a lot of research that has been done on the benefits that are realized in these co-management agreements following land claims on protected areas and elsewhere. Not elsewhere, on protected areas. And very often the received benefits are nothing compared to the expected benefits. This is dependent, of course, on the resources that are present to begin with. In the Makuleke case, that was a claim on the Kruger National Park itself, and so obviously it was a very high-profile claim, lots of money involved, and that has been touted as a real success story. It's kind of a bit more complicated than that, but in general, it seems as though people are benefiting from it. However, the Dwesa Tlebe Nature Reserve is much smaller scale. It's a small reserve on the Wild Coast in the Eastern Cape, and there is very little support there, very little money. And the people there actually tried to take the park back by force because they felt they weren't receiving the benefits that they had been promised. So they came at the fence of the park with stakes. They literally tried to take the park back by force, and they've been grazing their animals there basically since they received the land back, in contravention of what actually was agreed. My final little example there is Mkombati Nature Reserve, and what's interesting to note there is just the size of the claimant community. In that case, they started out with 100 claimants, and that's a manageable number. But because of the traditional leadership structures in that case, the claimant size increased to 15,000. And if you include all the beneficiaries, I mean, claimants are just one person in a household. If you include all the beneficiaries, that's 30,000. So, I mean, if you divide whatever you're earning, whatever percentage the community is getting from what the protected area is gaining through tourism, if you divide that by 30,000, it's really not all that much. That's my one little spoil sport point. And the other one is that in this whole presentation, I've been assuming that protected areas are the best way to go about biodiversity protection, and the only way. Sorry, I'll be one moment. But that's not necessarily quite valid. There's been quite a bit of scholarship surrounding the vulnerability, the spatial vulnerability specifically of protected areas. They also tend to create negative attitudes through their creation, and they don't take account of the fact that ecosystems are dynamic and need to change, specifically in, also with climate change. There needs to be a lot of adaptation there, and there will be. And so all of that leads to, well, some people have said that protected areas are kind of placatory. They're not, and not much more than that. So perhaps it would be good to look at alternatives as well as protected areas. Things like land stewardship, which we heard about a lot yesterday. Also green cities, like the one in that picture there. And in general, just ideas that would defeat the human nature distinction. Yeah, that's me. I just wanted to show you that picture finally. That is a design for an actual design for a city that they're thinking about building in South Korea. I think it's quite cool. Just wanted to let you just watch the space.